Hi, everyone. Thanks for tuning in today. We will get started at 11 o'clock. I just wanted to give people a chance to join in. Thanks for tuning in. We will get started in just a minute. All right, well, it is right at 11 a.m. So let's go ahead and get started today. I'm Sarah Miller. I'm the Vice President of Marketing and Strategic Communications at the Small Business Association of Michigan. And I am glad that you're able to join us today. Um, we have designed this webinar with our friends at the American Society of Employers to help you comply with changes to the Fair Labor Standards Act. So I'm really pleased to welcome Mike Burns with ASE as our expert panelist today. ASPAM has enjoyed a very long-standing relationship with ASE. They really help our members through a variety of human resources related services, including our very popular Ask an Expert hotline. So Mike's about to get started, but a couple of housekeeping notes. He will take questions, but let's save those for the end of the presentation. You can feel free to use the Q&A feature or the chat throughout so you don't lose your thought, and then I'll go ahead and moderate that Q&A at the end. This recording or this webinar is being recorded, and we will make that available to you later today. So again, thanks for tuning in, and I'm going to turn it over to Mike.
Thank you very much, Sarah, and thank you for having me. I look forward to this. This is kind of a neat little class that we do in a broader format. We're going to kind of focus on, of course, the Department of Labor changes that occurred, the regulations that were issued shortly ago. I am going to provide a little context, I guess, and background on the Fair Labor Standards Act, so you'll know exactly how to use this updated regulation. It has been a very busy time as far as regulation publication has gone. We had earlier this year the Pregnant Worker Fairness Act regulations come out. The Equal Employment Opportunity Commission has issued updated guidance for harassment. And even the FTC is trying to get into the act with employers and banning non-competes. A lot of this is being challenged in the courts right now since the publication of these regulations, and the FLSA regulations that I'm going to talk about are no exception. I want to talk about where that's at in a little bit, but I do want to give you kind of a primer on the Fair Labor Standards Act so we can kind of see how all this fits together. Of course, the Fair Labor Standards Act is a federal law. It does cover a spectrum of employers, typically with gross sales of over 500,000 or more, or two or more employees. The Michigan law is very comparable to the Fair Labor Standards Act. If the Fair Labor Standards Act does not touch on an employer because of their size, the Michigan employers employment law will cover that particular employer. One exception is where the federal law has not kept up with the Michigan's minimum wage law. That does take precedent over the federal law. We'll see in a second, what the difference is, but keep an eye on this because there's a court case at the Michigan Supreme Court level that's going to rule on whether the way the Michigan minimum wage law, as well as another law, the paid time sick leave law, passed back in 2018 by a adopt and amend process by the legislature and the governor's office at that time. That was challenged constitutionally, and we're actually waiting for a case. If the adopt and amend process that they used back then is ruled unconstitutional, we will revert back to the initial law that was passed, which would be the Michigan paid sick leave law, as well as the minimum wage law that would be basically have to be amended and such. I'll show you a second where things are at right now. It's capped off at $12 an hour, but we're currently at $10.33 an hour. It has some step ups there. That every year, except for a year when the consumer price index by legislation got in the way of one of the step increases, we recovered that this year, and technically this will go out to 1031 if the law again does not change. Both FLSA and Michigan's employment standards law requires employers to track time for hourly and non-exempt employees, and both require payment of overtime at time and 1/2 for work over 40 hours in a week. Okay, what has changed with the publication of the new regulations announced 4/23/2004? The salary level test was increased. It was $600, about $38,000 up until, and continues till next week, where it will become go up to $844 per week, or $43,888 per year. Shortly after that, in January, it'll step up big time and go up to $1,128 a week, or $58,656 per year. I'm going to explain where this fits into exemption and non-exempt classification, and we'll get right into that. But keep this in mind. What this means is if you have exempt employees who are currently making less than $43,888 in a year, next week they will become non-exempt, or you'll have to increase their wages or make another couple changes or suggested changes in order to keep up with and maintain that exempt status for those exempt employees. There's also a classification called highly compensated employees. And this particular classification, you can deem a job exempt if they are making at least $132,964 a year, again, as of next week. And they perform one of the primary duties of an exempt classification. So it's it's kind of a job duties, and we're going to talk about the job duties test so that it all fits together, as I said. But if the job meets one of the job duties components for an exempt classification and makes $132,964 a year, they too can be deemed exempt. And then again, at this particular little component will increase. It goes up to $151,164 in January 1st. And there is updates based on cost of living every 3 years. So we will see going forward if these regulations are allowed to do so. Big qualification there. If these regulations are allowed to do so, they will adjust every 3 years, which means employers will have to go through what we're doing now in preparation again in July of 2027. Okay, so where does the salary level test fit in when you're determining whether a position in your organization is exempt or non-exempt? Some of you may know, and maybe all of you know, there are 5 major exemptions under the Fair Labor Standards Act. Now, in saying that, there are a myriad of smaller industry-specific exemptions. Agriculture, I think, would be most prevalent in Michigan, where they're exempted from the exempt classifications under the FLSA. Another odd one is movie projector operators, for example, as how industry specific it can get. A more common one would be there's an exemption for a car dealership, people who are involved in the sale of cars. I'm giving those as examples, not that we're going to talk about it, because the most employers out there wrestle with the executive exemption, the administrative exemption, or the professional exemption, with some also having to look at whether their salespeople fall under the outside sales exemption or the computer professional, which is as the FLSA goes, a fairly recent computer, I should say professional exemption there. It was established back in 2004 and has a unique feature to it where you can pay it hourly as long as you're paying at least $27.63 an hour. It otherwise performs the responsibilities, the duties of a professional computer professional, and we'll look at that a little bit closer when we get to it. But I think the main set of white collar exemptions that you may be looking at are the executive, administrative, and professional exemptions. So here we go. To be classified legally as an executive, professional, or under the administrative exemption, those 3 classifications, you have to meet a salary level test, which is what changed with the recent Department of Labor regulations. You have to meet the salary basis test. This means somebody should be paid a salary. We had a Supreme Court decision about a year and a half ago, you may have heard, called Helix, where a position in the oil industry was paid very, very well, but they were paid on a day rate. That was deemed by the Supreme Court to not meet the salary basis test. In fact, one of the justices even questioned whether they should, the Department of Labor should even have the authority to, set up tests like this under the Fair Labor Standards Act. And that is bringing rise to more challenges against the whole law itself that we'll see what happens. But in terms of what's going on right now and what we have to comply with as employers, they have to meet the salary level test, be paid on a salary basis. And then everybody kind of looks over and say, well, a lot of people say, well, I pay a salary, that's okay. No, it's not. They got to also meet the job duties test as an executive, professional, and administrative employee or administrative employee. And let's take a look at those really quickly. Again, going to have to meet the salary level test starting next week, which increases to $844 and then up to $1,128 per week. We talked about the highly compensated, and they must also meet the job duties tests that we're going to see right here. Want to mention, I think at this point, I put this in there this morning because we are seeing right now that there are 3 lawsuits challenging this Department of Labor rule. The one most likely to get in the way of this new rule is at a case called Texas versus U.S. Department of Labor. It was filed at the start of June, really quickly after these regulations were initiated, and we had a hearing just yesterday. We expect to see a decision on whether these regulations will be enjoined or not within the next week. The same court is hearing this case that shot down the Obama regulations in 2016, coincidentally, or less than coincidentally. I think we had a little venue shopping by the by employers out there. In any case, some reports out of the hearing yesterday was that the court, the judge, the same judge who heard it several years ago, again questioned whether the Department of Labor had the authority to issue such regulations. So with everything I'm going to tell you today, stand by, because in very short order, we will see a decision from the Texas Federal District Court down there. Also going on, challenging these regulations and is a joint resolution in both the House and Senate seeking to eliminate the 2024 regulations. This is not going to get too far because the Biden administration is behind the issuance of the Department of Labor regulations, so it's probably going to get stopped right there. Best hope that we are set with the status quo would be if the Texas Federal District Court puts a stay on these new regulations. So with that said, let's really quickly look at the regulations, the tests that have to be met. As mentioned earlier, the salary basis test prohibits deductions from salary for exempt employees. An employee is not paid on a salary basis if the deductions from the predetermined salary are made for the absence occasioned by the employer or by the operating requirements of the business. So you can't, with an exempt employee, they have to be paid for any week in which they do any work as a general rule. So if deductions are made, if, for example, you had to close down because of a storm on a Wednesday or Thursday, for example, then you still have to pay that exempt employee's salary, as opposed to your non-exempts or hourly, where you could basically pay only for the work performed. More definitions around the salary basis test. The employee, as an exempt employee, must regularly receive a predetermined amount of compensation pay each period. Compensation cannot be reduced because of variations in the quality or quantity of work performed. Must be paid a full salary in any week in which the employee performs any work. But you need not pay an exempt employee for a work week and when no work is performed. So again, be careful if you're ever doing for any reason, deductions from pay on exempt employees. You could bring down that classification as far as the Department of Labor is concerned, and create some problems for yourself. Okay, in all three, exempt, executive, professional, administrative, there's a primary duty that the employee, in being exempt, this is what the job is primarily meant to do. So it means the principal, main, or major most important duty that the employee performs. Determination of the employee's primary duty must be based on all the facts in a particular case. If you ever get involved in a wage and hour dispute, and I advise you to have a really good updated job description, but that being said, it's very fact specific. So fudging a job title or fudging, job duties to make them a little bit more, as we say in the comp area, rather than making the position watching eggs hatch, you write in the job description, well, this position really creates life. Big difference there in terms of the primary duty, if you think about that. So keep in mind that when we go through these job duties tests, that the primary duty is what we're really looking to fit within to meet the particular exemptions. Important point, again, just to make clear, the new regulations did not change the executive, administrative, or professional duties test. So nothing touched, no new regs touched this today. All they did was change the salary level test in an attempt, and this is what they want to do. They want to increase the number of non-exempt hourly employees. I think this is targeted mainly towards the hospitality and retail industries, unfortunately, because the government, Department of Labor, has felt that many of the positions are paid too low, and not eligible for overtime. That low pay is perpetuated, if you will. So The executive exemption, probably one of the easiest to understand in terms of what you're trying to do, is your supervisors, managers. You got to be careful. Sometimes, people will make a work leader exempt. That's not necessarily the best thing to do. It depends on what we're going to look at right here. The primary duty of an executive to get this exemption is the management of an enterprise or a customarily recognized department or subdivision thereof. So your basic supervisor of any operation, as long as they're directing the activities of two or more other employees. And here's an important thing to keep in mind, a definition there. The supervisor positions, managers, supervisors, has to have the authority to hire or fire other employees. And here's a change that went into effect about 20 years ago, so it's been around a while, or whose suggestions and recommendations as to hiring, firing, advancement, promotion, or other changes of status other employees is given particular weight by management. And this came about because in many of the larger organizations, many employers did not want to give or no longer want to give one position all that authority. They want to take a look at, terminations because of a lot of laws that come into play there, and recognizing that an employer may have levels of decisions before somebody is disciplined or discharged or whatever. They modified this duties test back a long time ago and said, we're just going to say the primary duty of the current executive exemption, all they have to have is the recommendations around personnel actions have to be given particular weight. One of the most confusing and misapplied exemptions is called the administrative exemption. Remember, this law was implemented back in 1938, and it's written in a context and a content, I guess, from my perspective, that seems to be very, very lax. In other words, oh, okay, a lot of people, and let's take a look at the definition right now. What is the primary duty of an administrative exemption? It's the performance of office or non-manual work directly related to the management or general business operations of the employer or the employer's customer. So this is, you could easily say, well, this is a clerical position. I would not, I'm recommending you do not consider this a clerical position, because if you look at the next primary duty within this test, whose primary duty includes the exercise of discretion and independent judgment with respect to matters of significance. You read this, you may say, okay, that's fine too. But in reality, we are not looking at somebody who, like an executive assistant, the position has to have the authority to make decisions outside of policies, procedures, contracts, whatever. It's a high level policy making decision. And here's the where people get very confused, and this even has a unique name. It's called the production dichotomy. If the position has any direct contact with what the organization produces or sells, it doesn't qualify for this exemption, because that would not be performance of office or non-manual work. Where a lot of employers get tripped up is, well, maybe, I've got somebody who I put in charge of scheduling production. That would be putting their hands on production and would not pass this first mini test within the administrative exemption. So first, they have to be a backroom position, would be one way to put it, performing office or non-manual work. And then they would have to have the authority, the discretion and independent judgment, and have the authority to exercise that to matters of significance. So what are we talking here? We're talking tax specialists. We're talking insurance adjusters. We're talking some pretty heavy duty positions, and we can't apply this despite the common language that this position's job duties tests are the way it's put. It is not your general clerical person who you perhaps give a little authority to. That authority is most likely derived from procedures that are followed, manuals that need to be followed, supervisors' directions, processes that need to be followed. And this person really has no authority, or the job would have no authority to change that without obtaining permission. To give you an idea of, well, first, the position, the definition consists of performance of non-manual work directly related to management policies or general business operation, as opposed to work primarily involving production or service or sale of goods. That was that production dichotomy I was talking about. But what I was going to get at is independent judgment and discretion. A lot of positions seem to provide, exercise independent judgment and discretion. But as I said, this is supposedly it's supposed to be a high-level administrative position, and it involves the comparison and evaluation of possible courses of conduct and having the authority to make independent choice free from immediate direction with respect to matters of significance. Even matters of significance has a term of art to it, because you just can't put a dollar amount. What I often say in a class is, what if you give $15,000 to a delivery person to deliver to a bank? Now that delivery person has a lot of money on them. Is that matters of significance? And then they're even allowed to determine what route they take to the bank you want it delivered to. So there's authority to make independent choice, but it's not at the level that this exemption is looking for. So what do? It does not include use of manuals, guidelines, or software packages to make determination. It does not include the use of skill in applying techniques, procedures, or specific standards. It does not it's not applying knowledge followed by prescribed procedures or determining which procedures to follow even. It is not determining whether specified standards have been satisfied, even if there is some leeway in reaching the conclusions. It is not performing inspection functions by following established techniques and procedures with skills acquired through special training or experience. And it is even not formulating recommendations based upon development of facts concerning conformity with known standard. For going further, it is not comparing items based upon established standards known through experience or written manuals. It is not screening applicants or conducting interviews to determine satisfaction of certain minimum qualifications for our UHR people out there. It is not making decisions that do not commit the employer in substantial respects financially or otherwise, or it is not negotiating settlement with policyholders where the individual is not given reasonable latitude in carrying out those regulations. A lot of decisions, but the bottom line is this is just a very high level policy making position and can't be mistaken for an administrator or clerical person who's following established procedures, rules, and policies and so forth. Okay, that is a brief overview of a very the exemption that's, I think most employers, if they're going to have a problem with any of them, that would be where they'd misclassify a position. The third exemption I want to briefly go through is the professional exemption. This is actually two exemptions, but we're going to talk mainly about the learned professional exemption. There's also a creative professional exemption that I think for most of us, we're talking musicians, poets, literary writers, and so forth in that creative exemption, where I think most employers live around this particular exemption is the professional positions. The professional exemption, our primary duty there is they must be in the performance of work requiring advanced knowledge in a field of science or learning, customarily acquired by a prolonged course of specialized instruction. Okay, what are we talking about? This is old school. Again, 1938. We're talking attorneys, architects, doctors, dentists, accountants, pretty much any position that requires going to school specifically for that degree. But be careful, because it's old school, not every degree, if it's got, for example, marketing in front of it, creates a learned professional exemption. Again, work requiring advanced knowledge. This means predominantly intellectual in character, and which includes work requiring consistent exercise of discretion and judgment again. Professional work is therefore distinguished from work involving routine mental, manual, mechanical, or physical work. A professional employee generally uses the advanced knowledge to analyze, interpret, or make deductions from varying facts or circumstance. And it cannot be attained at the high school level. I come across a lot of positions that are deemed professional, but the job description itself doesn't even require a college level degree in that case. This again is not just any degree you can get out of a college. The field of science or learning are your traditional or conventional ones: law, medicine, theology, accounting, actuarial computation, engineering, architectural teaching, various types of physical, chemical, and biological sciences, pharmacists, and other occupations that have recognized professional status. If yours doesn't fall into this, I would be very careful using that professional exemption. The one area that I think you really might be able to, you'll note, I think, that there's not a computer field of science and learning here, and that is because it has its own particular exemption, is what I want to say here. But that particular computer exemption, as we'll see, is really something that the person should have a computer science degree. It is not going to be achievable by just getting certifications to be certified or proficient in certain programming like Microsoft Word or Excel or whatever. The position has to be one that actually can do the programming or code writing around a program, and that is part of the job. So be careful in terms of the computer exemption. We'll see a little bit more here, but I would recommend looking at the old school degrees, if you will, that we recognize as having that professional classification. More definitions, again, customarily acquired by a prolonged course of specialized intellectual instruction. It's restricted to professions where specialized academic training is a standard prerequisite for entrance into the profession. The best evidence of meeting this is a requirement of having an appropriate academic degree. So those are the main exemptions. I also mentioned the outside sales position. Don't get tempted to classify in-house salespeople. And again, retail has its own exemption there that I'm not getting into, but don't get tempted to label a in-house salesperson as an outside salesperson just because they might run out then and again. In that particular exemption, they have to be out specifically. That is the main part of their job, is to be out there selling. And they could also do not have to be paid a salary, because they can also be paid a commission or other incentives that go with that. Again, I'd love to talk more on the computer professional. Just be warned. Make sure if you've got a help desk person there, or somebody who's just doing troubleshooting with your computers, you look at that position twice. It probably doesn't reach the level of the computer professional as in that particular exempt classification status. Now, exempt employees, as I said very early in this program, have to be paid a salary for any week in which they do any week, and you don't want to make deductions from pay, except in 7 circumstances. I'll try and get there, get you down to this. You can exempt from an employee 1 full day of pay if they are out for personal reasons other than sickness or disability. I guess the only one that comes to mind with me is, somebody has to go out and get a mortgage, or had to run out and help a kid with a car problem or something. Anyway, that it has to be 1 full day. So if they perform any work in a given day, even though they might take the other half of the day to run this personal reason, they would still be expected to be paid. They would not meet this no pay docking rule. Absence from work for 1 or more full days due to sickness or disability. If deductions are made under a bona fide plan, I used to always get questions. Can I, take pay away from this exempt employee, because they, were sick an exceptional number of times, for example. What you can do in order to deduct from pay without risking the classification, if the person's out for 1 or more full days and you have a paid sick leave policy that replaces their pay. And a lot of employers in Michigan over 50 have this because of the Paid Medical Leave Act that we're under. But if you're under 50, you may not have gone there. You may, however, have vacation, vacation benefits or whatever that you allow people to use for sickness or disability. That's okay too. But under this particular exemption, if you make that available to them, to replace pay when they are sick, and they exhaust those benefits, you can then make a deduction for any full day that they miss once they've exhausted that PTO, that vacation, whatever you allow them to use when they're sick. If they exhaust that and then they take more time off, you can, in that case, deduct a full day or more of pay if they are out a full day or more. Don't want to give you any feelings that you can penalize somebody if they've in fact put any work in for that particular day. Other situations where exempt employees can be docked. They can be docked pay to offset any amounts received in payment for jury duty fees, witness fees, or military pay. They can be docked if it's a penalty imposed in good faith for violating safety rules of a major significance. Be careful there. Make sure that infraction it meets the level of major significance. I think if the violation would have a probability of causing injury or illness, you probably are getting there under the OSHA Act, but use some caution in terms of applying that violation of safety rule exception. Unpaid disciplinary suspensions of 1 or more full days imposed in good faith for violations of workplace conduct rules. Okay, we're going to give you a 3-day, layoff here, and we're not going to pay you for those days because you violated one of our rules. Proportionate part of the employee's full salary must be paid for time actually worked in the first and last weeks of employment. What does this mean? Well, you hire somebody on a Wednesday who's exempt, you don't have to pay them for Monday or Tuesday. If you let that person go on a Wednesday, you don't have to pay them for Thursday and Friday of that work as an exempt employee. And then don't forget about the Family and Medical Leave Act that exempts pay for, in this situation, intermittent leave, where people have to take time off for treatment or to take care of somebody. In that case, FMLA leave does not require you to pay that salary. Okay, with all this between now and July 1st, what do we recommend? Again, keep in mind that your exempt positions are evaluated by the Department of Labor on a position by position basis. So first we got to make sure we're looking at a bona fide exempt position, falls into one of the exemptions we've been talking about. We recommend that you go in and take a look at your your jobs and identify positions that are obviously exempt. Okay, your managers, supervisors, your attorneys, your accountants that you require a degree for, if they're obviously exempt, you're all set there. Next, you would want to go and identify those positions that are obviously non-exempt. They're production people, they're non-exempt, lower level clerical, administrative type people. And then there's one other thing that's come up, and I don't want to confuse the discussion here, but check your independent contractor status. The Department of Labor has issued earlier this year new rules on independent contractors, and they are very onerous towards, I think, employers and their independent contractors there. I'm not going to get into this. This is something I get in more into the class, but it's one I do want to bring to your attention. Again, independent contractors, different type of service provider there, but the Department of Labor is coming down on whether somebody who's being treated as an independent contractor should actually be an employee. So anyway, identify positions that are obviously non-exempt, and then you're going to evaluate it. And you're going to put them to the side, not worry about them. But then there are going to be these positions that are indeterminate. In other words, you can't immediately tell whether they are exempt or non-exempt, but you've been treating them as exempt. If that's the case, you can now, if the salary, when the salary changes next week, or even more so when it jumps even higher, January 1st, you're going to have to make a decision whether you want to move that salary up. That is the crux of what we're talking about with this change to the salary level test. If you have some exempt positions and this new salary level goes above 48,009 for next week, and you don't want to move it there, that position is going to have to be treated as non-exempt, which means record keeping, which means time and 1/2 over 40 hours to comply. And so if you want to maintain the exempt status, you're going to have to move that position up above $48,000 and change next week, and then up even higher January 1st, 2025 to that $58,000 level. I recommend, if you have some gray positions, as I call them, where they're just too difficult to determine, have a qualified employment attorney work with you, or a qualified compensation professional to do a position analysis. Even if the position, and because of the job duties test, may not be written very well and may lead a determination to a determination that the position it could be non-exempt, you might take a closer look at that position and see if you can shore it up in order to meet the job duties tests of the exemption. Be careful there. Make sure you do it right. So you've taken care of your exempt, you've taken care of your non-exempt, and now you've narrowed it down to these positions that are gray. You're going to look at those, make a determination as to whether if they meet the job duties test. Now you have to move that salary up to where the new regulations require you to. There are some employee relations concerns. Don't just do this and then say, sorry, you're now non-exempt if you've basically determined the position no longer meets, or you no longer pay to that level. You're going to have a little bit of disappointment on your hands to deal with. One good place to go is if particularly, and I think in many cases, employers, at least in our membership, if they've got actually anybody jobs positions that are exempt that fall below, they're moving it up. This is still for a lot of employers, the salary levels are high enough where it's not going to be a huge impact. Now, getting back to our friends in the retail and hospitality industry, it may have a big impact where somebody who was exempt, was making over $36,000 a year. You're not going to be able to move them to that $48,000 level. Not if I'm being correct on that. That 884 level per week level that we're going to meet next week. Then you're going to want to talk to that employee and say, hey, you might say, look, we did a reevaluation pursuant to the Department of Labor regulation changes, and we found that your position really should be non-exempt. The good thing is you'll be paid for, time and a half over 40 in a week, but we can control what hours you work, and that's the deal we have under non-exempts. Another disappointment might be, and there's a lot of status, let's face it, that goes with being exempt in a lot of employees' minds. So that's where if they get moved down to non-exempt, you're going to probably have to do some hand holding with them. Best option might be blaming the Department of Labor and pointing to these new rules if you're doing that. Also, if you're a bigger organization, train reclassified employees on why and talk to them, but their managers should understand how the changes have impacted those workers there. So again, communication, training, so your managers can talk to your employees about the classification they're in. All good approaches to making these regulation changes more palatable to the workers they impact. Lastly, account for the effects of other related areas. Now you're moving up your supervisors in order to maintain their exemption. You're probably going to be bumping up against the next level of professional or manager, if you will, in terms of pay. You want to keep an eye on pay compression as you move these exempt positions to the new salary levels that the regulation requires now. So that in very short order is a lot of information. What could be the penalties if you're found out of compliance? Unpaid wages and overtime. They'll go back and this is true even today. If you've misclassified a job as exempt and it should have been non-exempt all along, you're gonna, and let's just say this was just negligence. You honestly thought, you looked at the position and you honestly, or in good faith, I should say, thought it was a exempt position. They'll go back 2 years. But if it turns out you knew this position should be non-exempt and continue to treat it as exempt, they'll go back 3 years in the case of a willful violation there. So a lot of money, particularly as you get in bigger organizations who have classes of employees who may have been misclassified, this can really add up quick. Liquidated damages that can be awarded, attorney's fee, and then civil penalties. And you may not have known that individuals who play a key role, listen up owners, listen up principals, in shaping the employer's policy can be held personally liable. And this might be particularly concerning to the small employer out there who's got, 3 or 4 person shop. So keep that in mind. But the good part is it looks like we have a sympathetic Texas court. I want you to keep an eye on this. And if the I'm sure the SBAM will be putting something out on this, or I know we will to our employers, because we have a lot of employers that this law regulation impacts. In any case, keep an eye on things this week. Everything I've told you today, you might go back and just take a sigh of relief, and hopefully you're already compliant, and you can just go on as you have been. Okay, Sarah, do we have any questions? Did I sufficiently concern or confuse people out there?
It was definitely thorough, Mike, and thank you so much for walking through that with our members. I have not seen any questions come in, but I did drop the link for our Ask an Expert, hotline too, if people have questions later, and I'm sure you have your email right there. If they come up with something, they can reach out. But I will do a last call for questions, either in the chat or the Q&A. See if anybody has anything. But like I said, Mike, thank you so much for
Okay,
covering this today. And we will have this recording out to our participants and then available on our website for those who want to watch it on demand later today. I'm not seeing any questions, so I think we'll say thank you and goodbye. We appreciate everyone who tuned in today. Be sure to check out sbam.org/events for future opportunities that we'll have. And again, check out what ASE can do for your business. Mike, thank you so much for joining us today.
thank you, Sarah.
All right. Bye, everybody.